Hey everybody, my name is Robbie Crosier. I'm an M&A attorney and an adjunct professor of law at Texas A&M Law School. And today I wanted to talk about LOIs, some of the important provisions that are found in LOIs, the fact that some of those provisions, even though the LOI as a whole is called non-binding, some of those provisions might be binding, and what the consequences are for buyers and sellers. So LOI stands for letter of intent, and this is typically the first contract that's signed between a buyer and a seller in an M&A transaction, a small business acquisition. An LOI, that the title of that LOI will typically be letter of intent or non-binding letter of intent. Often it's non-binding letter of intent. And what that means, or what it's supposed to mean, is that the terms found within the LOI will not obligate you legally. You're not obligated to follow those terms at the expense of some kind of legal action if you don't follow them. So the idea here is that this LOI will not bind you. It won't impute any kind of liability upon you if you break these terms. Now, you may be asking at that point, well, what's the point? And when I first started working in this industry, my question was always kind of why do you even do this then? If the terms aren't binding, what's the purpose of taking the time to agree on them and sign this just to say, hey, we wrote out all these terms and we've agreed that none of them are actually going to we're not going to be committed to any of them. And it's for a couple of reasons. The first reason is, confusingly, and this is an issue we've seen some clients encounter before, even in an LOI that's titled non-binding letter of intent, at the top, some of the provisions can be binding, and often a few of them are almost always binding in these acquisitions. The three that come to mind are what's called the exclusivity clause. That's one of them. The governing law clause, and the confidentiality clause. And to kind of break those down, what each of those clauses mean, exclusivity is going to be an agreed upon period for which the buyer promises not to shop the deal with any other, the seller promises not to shop the deal with any other buyers. So a common exclusivity clause in small business acquisitions is 60 days. And so what that means in practice is that for 60 days from the time that this LOI is signed, the seller promises that they are not going to go around and offer this business for sale to any other buyers besides you. And that's a guarantee. What that's meant to do is give you some security as the buyer to say, hey, we know you're investing, buyer, as you're investing in time and resources to get this deal done. You're going to be doing due diligence. We don't want you to make those investments while we're, secretly shopping this deal to other folks and then have the business bought out from under you. So that's what the exclusivity clause is for, and that's what it accomplishes. Another clause that's binding is the confidentiality clause, and this is really important to the seller. Whereas the exclusivity clause is important to the buyer, confidentiality important to the seller, because during the due diligence period after this LOI is signed, a bunch of confidential information is going to be given from the seller to the buyer. The buyer is going to be given access to organizational documents, financial documents, other things that the seller really does not want anybody to see, especially folks that could be their competitor. So something that's pretty common in this entrepreneurship through acquisition space is the strategic acquisition of competitors. If you are potentially selling your business to a competitor and that they're going to have the opportunity to see your documents and, get a look at whatever your secret sauce is as a seller, you don't want them to have the option to then go and share that information publicly or use it to their own advantage during the course of their business. So confidentiality clause is really, really important to the seller. The last one being governing law, that is just the two parties decide which state's law is going to control the agreement. So in the event of a dispute, which state's law are you going to apply and view the terms of this agreement through? So exclusivity, confidentiality, and governing law are the three clauses that are most commonly binding in a non-binding letter of intent. And there will typically be some kind of language in the letter of intent stating that all of the clauses are non-binding except for those. There may be one or two additional binding clauses, but a good LOI will line item those out for you in a way that's clear. So now that we've covered which terms are typically binding and which are non-binding in an LOI, let's talk a little bit about what the purpose of an LOI is. So as I alluded to earlier, when I was starting out in my career, it didn't make a whole lot of sense to me, the idea that you would spend time negotiating these terms that are primarily non-binding. And that's still true that, even though we've got those three, exclusivity, confidentiality, and governing law, that are typically binding, the rest of the fundamental terms, things like the purchase price, which in an asset purchase, which assets are being purchased, which liabilities are being assumed, all of those, the closing date, things of that nature, are typically going to be non-binding. And so why do this at all? And the answer is generally because it is easier to negotiate these things. It is more cost effective and quicker to negotiate these things on the front end prior to signing an LOI than it would be after the LOI is signed while you are trying to draft a definitive purchase agreement. So some of this has to do with when attorneys get involved. It is common for deals that are within kind of the Main Street, lower middle market area, anywhere up to, say, 10, 20 million. It's common for attorneys to get involved at the LOI stage. For example, our firm, we prefer to get involved at the LOI stage if we can, because sometimes folks don't know what they're signing when they're signing an LOI. But it is easier, a general rule of thumb and a good principle is that it is easier to take the time up front to get as much detail papered up as you can in the LOI within reason about the deal structure. So if you have some kind of creative financing, you want to put that in the LOI. If there are specific assets that you want excluded from the purchase, you want to make sure that's in the LOI. If there's going to be an employment agreement that the seller enters into as a part of this purchase, where the seller will be employed by the buyer as a consultant or a manager or something like that, you want that referenced in the LOI. If there's going to be a lease, let's say the seller also owns the property that the business is situated on and is going to lease it to the buyer, you're going to want to mention the fact that there will be a lease in the LOI. All of these things, including another thing I wanted to mention, are contingencies. There are typically going to be conditions to close, or contingencies, which are certain conditions that must be met in order for this purchase to go through. So that's going to be things like, regardless of whether or not the seller is a landlord themselves, if there is a lease that the seller's business operates under, the assignment and assumption of that lease is going to be a condition to closing. If the buyer is purchasing this business with some loan, like an SBA loan, the successful acquisition of that loan is going to be one of the conditions to closing. Other things of that nature, you want to make sure that all of those are covered in the conditions to closing. And so the more detail you can get up front, the more likely it is you're going to have a smooth acquisition. More likely it is from the buyer's perspective that you're not going to be accused by the seller of trying to retrade the deal terms after the fact because you were reluctant to put something in the LOI. We've seen that in the past. Sellers, because anybody, especially for businesses that are listed on BizBuySell or some other kind of online brokerage or with a local business broker, these sellers for more attractive businesses will get a lot of offers. And so if they have been marketing their business for sale for a while, they will typically have a relatively low amount of patience for tire kickers and might be sensitive to buyers that they don't think are serious. So you want to be sensitive to the idea or the impression that you might be trying to retrade the deal. And one of the ways that you can do that is by making sure all the terms are clear and agreed upon upfront in the LOI. So those are some reasons that the LOI is important, even if most of it is non-binding. I hope that helped shed some light on this process and the importance of an LOI in a small business acquisition. And with that, we will talk to you later.